Amy. And okay, thank you. And I am the managing editor of Loyad. Loyad was founded by Toby Adebowale and our dear friend Adavize Alao, who is now of blessed memory. Over the years, we have worked to bring light, to shed light to emerging areas of law, and we have also worked to. Oh, sorry. Can everyone hear me? Okay, great, thank you. We have worked to shed light on various areas of law, and after the passage of our dear co-founder in 2019, we decided to start this symposium in honor of an area of law which he was very much involved in. And we would like to once again thank all our partners who have continued to support us over the years. Would like to thank everyone who has been a part of this journey. Every year is always another time to not only to give back, to this area of law that Adavize was passionate about, but also to remember his legacy. And in line with this, I would like for us to observe a minute of silence in his honor. Thank you very much.
Thank you very much, Banker Ilori. Thank you for that welcome address.
Allow observing a minute of silence in Adavize's honor. Can you hear me?
Oh, so sorry.
Alao, can you hear me?
Yes, I can.
Yes.
1 minute of silence.
Yes. Thank you. Thank you, everyone. May Adavize's soul continue to rest in perfect peace. Over to you, Alera.
Amen. Thank you very much, Banker. So proceed with the session for today. We would be going straight to the address by Dr. Simi Akintoye, Senior Lecturer, the Montfort University, Leicester, United Kingdom. Before we bring Dr. Simi Akintoye, I would like to especially appreciate our sponsors and partners, Dua Ali, Alex Adedipe, Tech Hive Advisory, Garnet Legal, Hi KIGIA, and Legal Nigeria. Thank you very much for putting this together, and obviously our organizers, Loyad. Thank you. So over to you, Doctor.
I think Dr. Simi isn't here yet. So, but I can see that our keynote speaker is here already. I would like to once again appreciate her for her support and for actually being here on time. So we could just move to our keynote speaker in person of Morayo Adebayo Adisa. Thank you so much, Ma, for joining us.
Thank you. It's my pleasure to be here.
You have the floor now, Ma. Can we have your keynote address?
Oh, you would like me to proceed?
Yes,
Okay. I need to share my screen. I think screen sharing is disabled. I have a presentation to use.
oh, great. We'll
Okay.
fix that.
You can go ahead now.
Okay, thank you. I'll try again now. Okay, so the topic that I have before me today, good morning, distinguished ladies and gentlemen. I stand on all existing protocol. I hope everyone can hear me clearly. Okay, thank you. The topic that I have before me today is privacy and data protection in Nigeria, the legal framework. Now, as an introduction, I just wanted to use this to set the tone for the paper. You know, we typically hear people say data is the new oil. And when they say that during this, for the purpose of this introduction, I want us to be aware of two things. First things first is that there's obviously money to be made from data, both in its raw and in its processed forms. Obviously more money when processed, but there's still some money to be made in the raw forms as well. And then the second thing, which perhaps is the more important thing, is that because of that, there's a rush to harvest, to mine, to extract as much data as possible from anywhere that data can be extracted from. And if you think about oil exploration, you would need a license to do that. But with data, you don't really need a license. You just need to provide a service, and you have consumers, approach you for that service, use your platforms or come to you and you take their data manually and then you store it digitally. And then so when we have that in mind, the questions that we have to ask ourselves is how much is too much and how protected is the consumer or data subject from unfair exploitation. Now, what are the types of data that could be implicated, in this conversations? Your identity, your financial information, your location, your interests, your movement tracking, where you go. Think of your Fitbit, your Apple Watch, your phone, your social connection. Who is your brother? Who is your sister? Who is your friend? Who is your mother? When did you talk to that person? When you send an email, sometimes you're sending an email and Google is telling you forgot to attach something because in your email you said, please find attached. So you see that communication that's already been processed and assessed. And then your social media activity, your health information, really any information that can be provided or stored digitally. Because sometimes you're thinking when you don't provide this information via digital platforms, you don't bear in mind the fact that this data could become digital and then become potentially exposed. So for example, you go to the hospital, you're sitting across the table from your doctor, you're just talking to your doctor, you're not mindful of the fact that that data could eventually be digitalized and therefore exposed. So in every aspect of our lives, we should begin to have that mindfulness that every information about us could potentially become digitalized, whether we've provided it on a digital platform or off a digital platform. So the question then is, or the concerns around that is, how secure is the platform on which you're providing the information? Who has access to that information? What is the person accessing the information going to do with your data? What data do they actually have access to? Because sometimes you actually don't know the amount of data that is being taken off you. Sometimes you feel like you've only given ABC, but in the process of giving ABC, you've actually given all the way to Z as well. Now, sometimes we don't know how much data people have on us. Then the other thing is, how safe is a storage process, concerns around safe storage and processing. And then who will the operator pass my data on to? So if I give my bank my data, who is my bank likely to pass that data up onto? If I give my healthcare provider my data, who is that healthcare provider likely to pass that data onto? Those are the key questions here. And before we go into the legal framework, I wanted us to take a look at an example from Zoom. And we're on Zoom at the moment. So early this year, FTC, which is the Federal Trade Commission and the equivalent of the FCCPC in the US, alleged that Zoom misled users to believe that it provided more security, on its platform than it actually did. So for example, Zoom said that they provided end-to-end encryption for communication via Zoom. But eventually it turned out that, yeah, it might have been end-to-end encrypted in code, but Zoom itself had the keys to decode the communication. End-to-end encryption is supposed to assure me that it's just myself and you is listening to me that can have access to what I'm saying right now. But if somebody else who is the host of the platform is keeping the keys to decode what I'm saying, then how secure, how safe is that? And when you think about it in the context of this meeting that we're having, yeah, maybe perhaps it's not a big deal. But when you think about it in the context of, which goes to the second point on the side here, about who is using Zoom. I mean, during the lockdown, people started using Zoom for doctor's appointment, mental health professionals, for school, for all sorts of things that are supposed to be private and confidential conversation. So if Zoom, presented itself as having a secured platform and people trusted that or used that, or not mindful of whether it was secure or not, then clearly there's a compromised situation there. So now going on to talk about the legal framework in Nigeria. The starting point obviously is the Constitution. Then we have the NIDA Act of 2007. We have the Nigerian Data Protection Regulation 2019. And we have the Federal Competition and Consumer Protection Act of 2018. And then we also have other specialized legislation that relate to, cybersecurity, the Cybersecurity Act, the National Identity Management Commission Act as well. There's some provisions that relate to banking that CBN has put in place. For example, this year, CBN launched the open banking policy. And if you look at that policy, it has quite some provision around protecting the information of consumers or of users. And then the telecommunication sector also has quite a number of those policies. Is someone saying something? Okay. So data protection, what are the key rights of the consumer? Section 37 of the Constitution, that's really the starting point, the foundation of this. And it guarantees the privacy of every citizen, their homes, correspondence, telephone conversations, telegraphic communications, it guarantees that that's protected. Now, if you move on to the FCCPA, let's take it. Section 114 talks about your right to information in plain and understandable language. Section 123, which basically means that, for example, when you are signing up for a new, let's use social media, you're signing up for Instagram or Facebook, and then you click that you've read all the terms and conditions and you agree. Have you really read it? Do you really agree? Because you haven't read it. So you can't agree with what you've read, but you just tick it. And the reason why you do that is because if you were to decide to read it, it might take you another hour or two to fully read it, and then maybe another day or two to fully comprehend what you've read. So you really don't want to do that. You just tick and you move on. So are we going to say that that's plain and understandable language? And then this next thing is, what kind of language is used in it? Technical stuff sometimes that people are not really going to understand. So are we going to say that that's an informed consent that the consumers provided? I'm just throwing these questions out there. I'm not answering them right now. The second thing is section 123 that talks about the right to full and frank disclosures that are not misleading, deceptive, or false. So you see some things, for example, sometimes you're signing up for a new promotion, or you're participating in something, you're participating in a service or something because there's a promotion attached to it. And then they now tell you at the end of that thing that this is subject to terms and conditions. Why don't you put it out there? Why don't you make it clear to me what these terms and conditions are, the point in which you are asking me to sign up for this? I have to first go into the T&Cs, which, like I said, are lengthy, full of technical jargons, and I don't have the time to read it. So a lot of times people, participate in stuff, and then you get this subject to T&Cs, and at the end of the day, you find out that what you thought you were participating is different from what you actually participated in. Then the next thing is standards for exemption of liability clauses. If you ever taken the time to read these T&Cs, you see things like where they say that they wouldn't take liability for the loss of your data or breach of or leak of your data if blah 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 XYZ. And the question is, are those liability clauses always valid? Now, I would go into, if you look at 128 and 129, they talk about when liability clauses may be valid and when liability clauses will not be valid. If, for example, a liability clause is seeking to exclude something that arose as a result of the negligence of the provider, then that cannot be a valid exclusion of liability clauses. Now, going to the NDPR, I'm on the next slide, I still have more from the FCCPA, but let's look at what's in the NDPR for a bit. You see in the NDPR in Regulation 2.1, the use of data subject is only for the purpose consented to. Now, the question, let's go back to the question of what did you consent to? They've hidden it in the T&Cs. You may think I only consented to Facebook using my data because I want to talk to my friends, but you've also consented to Facebook using your data for advertisement purposes. You've consented to Facebook using your data for, location purposes and all sorts of things that you're not aware that you've consented to. So the question is, what did the data subject consent to? Security of data storage facilities is addressed in Regulation 2.1 as well as 2.6. Processing of consumer data should only be, so use and processing should only be with consent of the consumer or for the performance of the contract for which that consumer is a party. It's not for another contract. So if you have an agreement or a contract with another party, you're not expected to be using my data to try to fulfill that contract. Now, disclosure of specific purpose of data collection and consent, that's Regulation 2.3 requires that, data operators fully disclose to the consumer why they are collecting their data. The next slide talks about, let me just move, right to fair dealings. In section 124 of the FCCPA, you find that right to fair dealings, which means no question, no pressure, undue influence, unfair tactic in negotiating a contract or marketing or supplying a product or service. So let's think about that for a minute. Sometimes when you sign up for something, you are not aware that you signed up for something else as well. So those are called tie-ins, where you want to buy A, but they sell you A and B together. So let's think of that in a digital sense. You sign up for a service with Mr. A, but Mr. A brings along Mr. B, and you may not necessarily be fully aware unless you've read the terms and conditions. You just find that you're getting promotion emails from Mr. B as well. You're thinking, when did I sign up for these ones? You didn't realize that at the point when you sign up for A, you also signed up for B. Second thing is excessive data extraction. For example, a company may only need maybe 5 sets of data from you to provide you the service that you are contracting them to provide to you. But then they make you provide 20 data sets. And because you want the service, you proceed to provide that, or you don't even question, do they really need this? You just provide it anyway. So that's a situation that could be a situation of undue influence. I don't want to conclude that it is, but typically if someone is in a position to provide you something that you really need and maybe you can't find elsewhere, they're likely to be able to exploit you and make you give up things that you would ordinarily give up if you have the choice not to, or if you're fully aware. And then harassment through unsolicited marketing emails, and then the hidden clauses. Now, section 130 of the FCCPA also talks about the right to performance of services in safe manner. That brings us to the question of how safe are the platforms, which ties back to the example of Zoom, for instance. Zoom promised a certain level of safety to its users, but didn't deliver on that level of safety. How safe are the platforms on which we provide our data? How safe are the storage platforms on which that data is kept? And then back to the NDPR again, you see in Regulation 2.8, it talks about the right of the data subject to object to the processing of their data, which basically is that I can say, no, don't use my data in this way. 3.1 talks about the right to information about the processing and use of data. Specifically, sub 9 of that talks about the right to request erasure of personal data. Then sub 14 and sub 15 talk about the right of data subject to receive their personal data and to transfer same to another data controller, which is called really data portability. And this is, I mentioned the open banking system policy earlier of the CBN. 3.1, 14 and 15 really provide the foundation for which, open banking is going to be able to thrive. Obviously, all of this, because open banking is really about making it possible for financial institutions to share their customers' data with each other and to share with other relevant third parties. But of course, all of this is supposed to be with the consent of the consumer. And then, so this right to move the data around, that's where, that's the foundation of that policy there. Now, so when you talk about the legal framework, we've looked at the legal framework, then let's ask ourselves some compliance questions. And that's where I want to end it today. First question is, as a business, what structures do you have in place for compliance? How, because it's good to have these policies that we have on paper, but how many businesses, and whether we like it or not, like I said, it's not just Facebook, Google, Apple, Instagram. Those are not the only people that are taking our data from a day to day. You walk into your hospital, they're taking your data. You walk into a supermarket, you use your card, they're taking your data. You walk into the bank, they're taking your data. Like almost every aspect of our lives, you sign up your kids for school, they're taking some data from your kids as well. You buy a new wristwatch, a Fitbit, Apple Watch, they're taking your data. The question is, big businesses and small businesses, and I think small businesses in particular need to start asking themselves these questions as well, because there's a tendency to feel like this doesn't apply to us. What structures are businesses putting in place to make sure that they are able to provide protection for the data of their consumers, of the people who have entrusted their data to them? You attend a program, you attend a conference, you have to fill in a register where they take your data. There was a time where selling that kind of data was money. And I don't know if people still do it, but basically all those attendance sheets you fill when you attend a conference ends up getting sold. I don't know if that still happens, but as businesses, that's the question we need to ask ourselves. What structure, because the time will come, and not really for the purpose of the regulator now, but even for the purpose of you as a business to be able to fully compete. A time will come when, consumers are more aware, and so they're asking these questions. And if you're not able to satisfy them that, you're fully prepared and able to protect their data, then they will move on to elsewhere. So as businesses, they need to start thinking about putting those structures in place. Now, to the regulator, what structures do regulators have in place for monitoring compliance? And I will answer that for FCCPC, and then I'll tell you also what I know about NIDA. That's those who are in charge of the National Data Protection Regulation. FCCPC, we have the legal framework, some of which I've talked you through, but I haven't talked you through the enforcement powers that are in that framework. But if you do take a look at the FCCPA, they're quite a robust set of provisions regarding enforcement, and there is that. And then we do have complaints channels for people to reach out to us to say that, hey, look, I have a problem with this issue here and there. We have the online portal, we have a mobile app for that as well. And obviously we have toll-free lines. And then we also, I think something I might add as well is sensitization, which is something we do from time to time. I mean, me being here is also part of that. Now with NIDA, I know that they have something called, they have a set of organizations that they call their data protection compliance organizations. What these organizations do is that they work with NIDA to help businesses put necessary structures in place. So back to question one, NIDA has these DPCOs who audit and look through systems of organizations to say, here's what you need to be doing better to protect the data of your consumers. These are the gaps we've seen. This is what you're doing well. This is what you're not doing well. And then that report, when they do that audit, a report goes to NIDA, and then NIDA is able to follow up on what recommendations have been made to that company in terms of how to improve their data protection compliance level. Now to the consumer or the data subject. What can the consumer or data subject do to protect themselves? I think that as civil society organizations, regulators, and as consumers ourselves, we should constantly be asking that question. There's the role of awareness that the regulator or sensitization that the regulator should do and civil society should do. But as a consumer, vigilance is your responsibility. For example, when you have the urge to tick that, when you have the urge to just tick that I agree with terms and conditions, be curious enough to read some of it, even if you don't read all of it. If you can read all of it, that's great, but be curious enough to read some of it and have an idea, particularly the security aspect of it. Even if you're not reading anything else, you should be able to ask yourself or answer the question for yourself that this platform on which I'm providing this information, how is this platform going to secure the information that I am providing to them? And you should at least make the effort to read the terms and conditions or the policies to find that out. And if you have the time, also read on who and who are they going to share this data with, who and who am I giving them the right to share this data with. And if you see something funny, ask them more questions about it. I think that's where I'm going to leave it today. Thank you very much for listening.
Thank you very much, Madam. Thank you for such an insightful and thought-provoking session. I, as a data subject and consumer, I've learned that I've learned my rights, and I've also learned that vigilance is my responsibility. I have to ask questions. I also have to ensure that I do not rush the data when it comes to the terms and conditions that could have usually done. Thank you very much, Madam. So we'll be having Dr. Mariah give her remarks before we take the panel session. We'll be having Dr. Simi Akintoye give a remark before we take the panel discussion for today.
Thank you very much, and thanks a lot. I'm really, really pleased to be part of this session. I'm so excited, and thank you for inviting me here today. Quickly, I do not want to share a lot, but just a little bit of slides that I've tried to put together. I don't know if you can see me clearly. And again, I am very, very mindful of this, and I have to, as much as possible, quickly talk about what I did a presentation on a few weeks ago, I must say. I think I'm having a problem with my screen. I don't know if I'm sharing the right one or whether you can see me. Some time ago, I got called to talk about privacy responses to COVID-19 crisis. I don't know if you can still hear me. I'm still having problem with my screen share. Can you see me, please? Can everybody hear me?
You,
okay, thank you very much. I just perhaps had a problem there in the first place. So I was talking, like I said, about privacy responses to COVID-19 crisis in Nigeria, and a number of things that the lady, Mrs. Morayo, if I'm right, spoke about came up with regards to what are citizens of Nigeria doing with respect to privacy and data protection. And I can see from a consumer point of view that Nigeria in itself is not quite there with respect to our responses to privacy, particularly in the advent of COVID. This trickles down to even consumer rights, it trickles down to protection, it trickles down to privacy data protection, particularly surveillance in this digital age. And it gives me a lot of pleasure to see that that now in Nigeria, these conversations are beginning to suffice. We are now at a point where we can make this, decisions as regards our privacy. I think we have a right as consumers, as data subjects, to sort of understand to what extent our privacy or our data protection rights are being implemented within the country. So quickly, I will talk about the importance of consumer protection, which we've mentioned in the past. Different sectors are responsible for collecting personal data. We know that consumer protection is important, particularly for national governments and consumer associations, stakeholders, to sort of look at the extent to which privacy and data protection can be enhanced within not only Nigeria, but also Africa. So in the advent of COVID, we have a new society, we have a new era where privacy and data protection becomes the order of the day. Several UN agencies, particularly, have provided guidelines and recommendations as to what we need to be doing at a global level. And when you look at the information technologies and communication sector, you realize that there is really, really minimal protection for developing countries like Nigeria, Togo, Benin Republic, even other countries in the Middle East that are still trying to catch up with the advent of privacy and data protection. So the International Communications Union, ITU, the World Banks have also developed what we call digital regulation platform, and they have a separate chapter on consumer affairs, just to sort of integrate consumer relationship, consumer rights protection into privacy and data protection. So these new technologies definitely have an impact. Big data, machine learning, consumer protection, privacy, they've identified a very important technology, which is artificial intelligence, that will have significant impacts on consumer protection. We've seen AI in telecommunications, we've seen AI in fintech, mobile industry. There's a lot of profiling and surveillance that are really, really gray areas for consumers and would raise a lot of questions in the future. Data is the new oil, as we always say. There is a lot of gray area within that we need to put into recognition. The UN Conference on Trade and Development talks about the impact of digital economy on consumer. And they've identified in a report, the 2021 report, some of the technologies that would impact. I've talked about data analytics, Internet of Things. These technologies have not only impact for privacy and data protection, but for sharing and transmission of data. The lady, Miss Murayo, that spoke earlier, talked about, you giving your data to A, and then you realize that B also has your data. The data sharing and data transmission that takes place between all these networks really brings to the fore the importance of privacy and data protection. And this will continue to grow. We shouldn't expect that this is something that would stop, or something that would come to an end. Just as we are now getting to understand the new normal of COVID, I think this is something that would continue to grow. What are the challenges that we face as consumers in this digital age? I think it's important, looking at the United Nations Conference on Trade and Development. A lot of workshops have been taking place globally within emerging countries to sort of understand the challenges that consumers face on a global level and needs to be addressed. I've put a few there. There are quite a lot of challenges here, but one of it is the limited awareness of e-commerce relevance among policy, lawmakers, consumers, and businesses. You'll be surprised that even businesses that sort of collect this data do not really have much awareness as to what they should be doing to the data. I mean, we've talked about data minimization in the past. If you're familiar with GDPR, minimization of data, making sure that data, not much data is collected, deletion, retention, and all of that. How do you sort of understand this, even as businesses, let alone delivering this as services or incorporating it into your day-to-day service for consumers? So that limited awareness not only is a problem of Nigeria, but emerging economies as a whole needs to be aware of this. What about the weak and regulatory frameworks? We do not have much regulations. We've talked about NDPR at EU level. We talk about the GDPR. US have its own regulations, but within Africa, we do not have that uniformity of regulations or in emerging economies that provide us that safe transmission of data as the GDPR does. So the weak legal and regulatory framework also impacts on online consumer protection, using your cards online, paying for things online. I think we must have heard of Paga and other mobile ways of paying. There's one in Nigeria now I was reading up. I'm not really sure what the name is, but it's as simple as using a PIN or scanning here in the United Kingdom, just scanning your card and paying. You're not very sure what level of information gets transmitted and is it regulated? That is the most important thing. So that weak legal and regulatory framework also helps to compound the problem. Thirdly, it's important to look at education for the digital economy. How much education do our younger generations and even existing generations have with regards to the digital economy? I think on a global level, there has to be governmental, worldwide education that would be sort of transmitted all through the country for people, for data subjects to be aware of this digital economy and the impact it would have on everyday activities, basically. What about limited access to internet, rural areas? Not many people are aware of or do have the resources to be able to navigate all the systems. You'll be surprised that even mobile phones is not, is yet to reach some really, really remote areas, and technology is still new, very, very new in remote areas, and there isn't much around this access to internet that helps it. And then you've got the one that really breaks my heart, and that's barriers that you have within the economy for different types of genders. So women barriers, youth barriers, engaging in e-commerce. There are some sort of cultural issues that impact on how people navigate or who has access to what should women be using the internet. And these are worldwide, general problems that the internet have posed, or that the consumer digital age have sort of posed on at a global level. And then you've got the skills, the skill set, lack of business skills, to adequate e-commerce skills for small, medium enterprises. They do not have the skill sets and the resources. So a lot of action for the government to take here, a lot of regulatory actions, a lot of frameworks that needs to be sort of addressed and looked into at a top-down level. And I'm really hoping that these conversations that we're having here today would sort of steer into those discussions, would provide us with useful, foundational, innovative conversations that would help us to collaborate and see how we can move, in effect, our own space forward, our own jurisdiction forward in getting into that co-creation mode. And the idea would be that, actors, stakeholders come together to sort of explore the opportunities amidst these challenges, because while we do have challenges, we definitely have opportunities for consumers in the digital age and what they should be doing to protect their privacy and data protection. And I hope we can continue this conversation today. So for me, that would be it, except there's any questions. Otherwise, I think it will be useful for us to sort of move this forward and see how we can continue the conversation. Thank you very much.
Thank you very much, Dr. Simi Akintoye. We cannot overemphasize the need for education on the digital age, and for also with the prevalence of the lack of regulation when it comes to uniformity of these laws. So we'll be moving straight to the panel discussion. Our panelists are ready for us, and it promises to be insightful. We're taking the conversations to the next level. I'll be introducing the panelists. First, we have I'm introducing the panelists. The moderator, Victoria Oloni. Victoria was the winner of the Law Students category of the inaugural Adavize Alao essay competition on data protection and privacy. Victoria Oloni is an innovative lawyer with significant interest in digital economy, data protection, cybersecurity, and general intersections of technology and law. She aspires to be a thought leader in data protection and digital economy. This has driven her towards making several publications and topical issues within the field. Victoria Olani is a training solicitor in detail commercial solicitors. And we also have Gbemi Ojedokun. Gbemi Ojedokun is an ambitious, focused, and committed legal practitioner with interest in data protection and privacy. She's a data protection and tech policy analyst with Tech Hive Advisory. She's a chartered secretary and administrator and holds a CIPPE certification with International Association of Privacy Practitioners. We also have Francis Monyongo. Francis Monyongo is a seasoned technology lawyer and policy advisor, currently in public affairs and government relations. He has 5 years experience in research and writing, policy development, stakeholder mapping and engagement, data protection, compliance, and corporate communications. He's passionate about tech, businesses, human rights, and data compliance, data protection compliance. We also have Ifedayo Adike as one of the panelists. He is an experienced legal practitioner with a demonstrated history of working in history in the law practice industry, skilled in aviation law, banking law, consumer protection, medical law, corporate and commercial law, legal assistance, arbitration, dispute resolution. With a master's degree from the University of Ilorin, he's currently pursuing a PhD with the University of Portsmouth, with his research focused on e-commerce and consumer protection in the European Union, United Kingdom, South Africa, and Nigeria. Also, one of our panelists for today is Timi Ebido Edo. He's a result-oriented, commercially astute lawyer. Timi Ebidi is a core member of the technology and digital economy and corporate and commercial practice area of the detailed commercial solicitors. He possesses deep knowledge and understanding of the tech regulatory section in Nigeria and has advised and assisted various startups and established tech companies within the tech ecosystems on acquisition, regulatory licenses, corporate structuring, and regulatory compliance. Wow. I can say that our panel discussion is going to be amazing. And I will be handing over the floor to Victoria Olani, the moderator of this session.
Thank you very much, Lara. I want to confirm that everybody can hear me, please.
Yes, we can.
Oh, yes, we can.
Yes, we can definitely hear you. Thank you.
Thank you very much for the introduction. I'm really excited to be a part of this panel this morning for 2 major reasons. One, 2 years ago, I was on the other side. I won the first edition of the essay competition, and now I'm here moderating a panel session. So it shows me how far I've come in my journey. But most importantly, I'm very excited about the topic consumer protection in the digital age, because it's not a conversation we have very often, but it's something that is very important. Because when you talk about digital economy, we talk about data, we talk about humans, and sometimes we lose sight of the fact that the avatars, the profiles, the pictures we see on the internet are real people, and they exist and they are affected by our actions, and there are real consequences for the things we do online. And then once again, we've seen the dynamics change over time. For example, consumer protection, before we say, oh, you have a right to inspect goods, and then you meet whoever you are dealing with when it comes to commerce or trade. But now, when you are ordering on Instagram, you are just hoping that what you get is good or fine, and then you're only dealing with a profile or an IP address. You don't know where the seller is. You don't know the state of the goods. You are just buying and hoping that it works out fine. So the dynamics for consumer protection has evolved and changed over time. I think this is a conversation we need to have very often, because with new technologies, AI, IoT, the law is even changing. The dynamics are changing from when it was just online business and e-commerce to more technical areas. And I'm not certain the laws are evolving with these new evolutions in tech. And this is why I'm so excited to be on this panel. Alera has given the profile of our panelists and they are experts in this field, and I'm sure they have a lot of knowledge to bring to the table, especially when it comes to this topic. Before I go to my first question, I would like to inform the panelists that this panel session is supposed to go on for about 60 minutes. And I have a number of questions, so if panelists get the maximum of 5 minutes to answer their questions, so we should make it as brief and as concise as possible, why not losing sight of substance in our responses. And then if anyone has something to add somewhere or extra knowledge, they can indicate by raising a digital hand. Thank you very much. So I'm going to go to the first question because it's important to give some sort of background or explanation to the conversation. And Bemi is going to be helping me with this. Bemi, are you there?
Hi, Victoria. Yes, I'm here.
Yes, thank you very much. Lovely to meet you.
Nice to meet you.
So, yes, can you just give us a brief background introduction to the concept of consumer protection, or is consumer protection the trade-off to get goods and services? What does it entail? What does it mean? And how does it apply at that age?
Okay, so Mrs. Morayo and Dr. Simi have, touched on this a little bit, but just to, add to it, I'll say that when you think of consumer protection, you think of, ensuring the safety of buyers of goods and services, safeguarding the consumers from, unfair competition in the market, or maybe unethical business practices such as false products and faulty products and false advertising. Basically just safeguarding the interests and rights of consumers. And we have consumer protection measures which are established by various laws that we have. For instance, in Nigeria we have the FCCPC Act. In America, we have the Federal Trade Commission Act. In the UK, we have the Consumer Rights Act. And these are just alongside other subsidiary legislations and sector-specific legislations, rules and guidelines that also make provisions for consumer protection. And these laws, they establish consumer protection authorities or agencies which are tasked with preventing unfair competition, deceptive acts, and just to basically regulate trade, prevent anything that may be deemed harmful to consumers. And over time, we've seen a shift from the traditional sense of trade. We've seen, due to technological advancements, we've seen that a lot of buying and selling now occurs on the internet, like electronically, hence the term e-commerce. So consumers now have like an online presence, and this confronts consumers with a whole lot of, obstacles in their online business interactions. So I think what we just need to focus on now is finding ways to, set up measures, amend our laws to reflect our current realities, and also, whatever may occur in the future. Because right now, it's not just like the physical offline trade that we have now. We have both the physical and the online trade. So we have to have, laws that also reflect, the online realities, the online obstacles that our consumers are also facing. Thank you.
Thank you very much, Bemi, for that very concise introduction. Now, flowing from what Bemi has said, maybe are you there? So, do you think that consumers have become more vulnerable with the development of new technology? Like with the coming of new technology, we notice that trade has become easier. You can get anything you want on the internet. You can buy anything on the internet at the click of a finger from the comfort of your house. So they have made things really easier and faster, and the world is now a global village, and we are just operating within one small sphere of the digital economy. But there are pros and cons to everything. Do we think that consumers have become more vulnerable because of the nuances and the dynamics of the digital economy? And do new technologies and business models raise new challenges for consumers? So maybe over to you.
So just shortly, I think yes, and I think the key speakers have touched on this. Well, I'll just go through them again, just to highlight them. Firstly, the fact that the transactions between consumers and businesses are now online, first of all, creates an issue of vulnerable commercial practices or unfair practices. An example would be, for instance, in the normal physical transaction, you have going to shop, getting the goods. But now the fact that all the interactions usually go on at the side, the goods you are getting might not necessarily be the correct goods, right? So there's that tendency or possibility of being treated in that way. Also, the online environment also creates an atmosphere where, or gives businesses the opportunity to prey on behavioral biases. Let me give an example. So you have shopping online, the whole idea of reference pricing. So you go somewhere, you see, get this discount from 1,000 to 500, even if the product was formerly 500 in the first place, right? So you have this baiting, time limited offers, scarcity queues, default settings. So all those things are just ways that businesses can push undue influence on consumers. Another way is because of the nature of data, I think which one of the keynote speakers discussed about as well. When you go to websites and it takes certain information, not necessarily personal information per se, but just your preferences, the amount of clicks, the amount of time you spend somewhere, right? So through that, businesses can build profiles, right? They can build consumer profiles specifically to you, and that can lead to and manipulate you in a way, all right, to purchase certain products. An example of something that went on, I think it was in the UK, where somebody who was a gambling addict, right, got bombarded even after they had made representations that they didn't want any more ads focused on gambling. Got representations over and over again. And that led to them going back into the habits and basically causing them harm because they lost most of their net worth. Also, it creates another unique, looking at it from the perspective of vulnerable individuals in the first place. So children, for instance, right? So the digital nature of services now has brought them so close to being able to partake in the whole service, right? So, and even if yes, they are quite experienced in the use of digital services, they don't really understand some of the things that go on in some of those transactions, right? So just the whole idea of children being able to access it as well. So you have, I know there were instances of kids through video games being making purchases of up to $1,000, right? So that's another way that digital has made it vulnerable. One also, lack of IT skills, especially in Nigeria. Right? In Nigeria, IT skills from individuals. So for instance, if you ask someone what a cookies is, I'm sure you won't understand what the cookies is naturally on your own. So there's this lack of knowledge on the nature and the ways in which information is being extracted from us. So there's a huge imbalance in favor of the businesses currently, the current climate. I think, yeah, that's all for now. Thank you.
Thank you very much, Maybe one thing I've noticed that has come up multiple times, even from the keynote to Dr. Simi's address to Gwemi's conversation and maybe his answer, is data. It's the digital economy runs on personal data. It's like the fuel that digital economy runs on. So there's the general saying, the cliche saying that data is the new oil, or data is the currency of the digital economy. it is basically practically impossible to talk about digital economy without talking about personal data. So, Francis, yes, Francis, can you tell us the role of data protection and privacy in consumer protection? What is the relationship they share?
Thank you very much for that question. Now, I think data protection is a business and human rights law. It is a form of consumer protection law. So that's where the relationship comes in. For example, under data protection law, you find things such as rights to data subjects. These rights include right to notification, right to access to information, right to objection, which are very, very strong data consumer protection aspects. So that's why I feel that there's a relationship between data protection and consumer protection.
Francis?
Yes, can you hear me?
I think you dropped off for a moment.
Oh, can you hear me now?
Yes, I can.
Okay. I was saying there's a relationship between data protection law and consumer protection law. And one can argue that data protection law is a form of consumer protection. It's implementation of consumer protection law. A good example is how within data protection, there are aspects such as right to notification, right to access to personal information. This is where, like, say, during a transaction or whether you've been transacting with a particular body, you can ask them for your history. You can ask them for information on how you've been transacting with them, especially now in this age where people are paying using mobile money, people are paying using cards. So there's a trail that is left. There's right to objection, there's right to deletion. So these rights have very, very, very strong consumer protection aspects. And that's why I see there's a strong relationship between data protection and privacy and consumer protection.
Thank you very much. Femi, can you give that the Nigerian context? Can you contextualize it within the Nigerian space, how data protection and consumer protection work together?
Hi, yeah, so just to add to what Francis has said, we hear the phrases, data is the new oil and all of that, so much so because, a lot of businesses, they rely on personal data. See, a lot of these tech giants or these tech companies, they traffic and hold like massive, insane amounts of personal data for their, businesses and all of that. And while some of the data that they collect may be necessary for the functionality of their digital processes, digital products and services. A lot of them, they collect the data for a host of other reasons, maybe to send like targeted ads and so on and so forth. And, it's just really unfair because, I should not, for instance, now, maybe I need to order something online and stuff like that. I should not have to have like my data shared with a whole host of other people just because I want to transact business online. So the role of data protection here would just be to ensure that, customer rights are protected, that businesses do not collect more data than they need to collect, that, even when they collect certain data, they're very transparent about what they're using it for and how they're protecting it and stuff like that. So data protection measures are basically just to ensure that, consumer rights are upheld, that there's transparency, and that, you know, consumers have a right of redress whenever they feel like their rights have been violated. And, you know, we may not have so many local examples, so to say, but I know that this year there were some sanctions by the Data Protection Authority placed on some digital tech companies and stuff like that for violations of, you know, the NDPR and so on. So, and then even now we have like the FCCPC that's joining forces with other institutions, you know, to investigate, you know, violations of consumer rights and so on. So while we do not have so many local examples, at least we're taking, you know, steps in the right direction. Thank you.
You brought up an important subject, the institutional bodies, governmental institutions that actually do with data protection and consumer protection. We saw in Mariah's presentation that consumer protection cuts across various sectors of the economy, in fact, all sectors of the economy, but the regulatory bodies are also more than the FCCPC. For example, she mentioned NITDA and the NDPR because data protection is an important part of consumer protection. So now, do we have enough policies? Do we have adequate policy measures in Nigeria? I think maybe try to answer that a bit in a part, but I'll need to maybe to focus and expatiate on this question. Do we have enough consumer protection policies in Nigeria at the moment? And if not, how can these policies be adapted? We have enough laws, in quotes, or policies or bodies that focus and deal with consumer protection issues in Nigeria at the moment. And if we don't, or even if we do, how can we improve, and how can these bodies or these policies keep up with new technologies?
Thank you. To a certain extent, I would say we do. The first keynote speaker went a bit into that as well. Now, but I would say we don't have enough, and also our laws are not exactly eating on the edge of the issues, because the nature of what we're doing don't really fall into some of the general provisions that we have that try to combat try to protect consumers in that sense, right? So yes, we have the NDPR, we have the SCPA, which give good provisions, fine. But I think we need more, right? So, and we also need more in terms of, we need more to focus in on the areas that are required. So you have special issues that come up in the e-commerce space. You have finance. You have issues that come up in the finances that are peculiar to it. You have issues that come up even in the tech, the health tech sector, right? So while we have, yes, we have general laws that we follow, we need to also bring these things down and make them clearer. It also helps both ways because it helps businesses as well in terms of when they are making their framework, right? So follow this framework and also helping protecting consumers where they can. Now, for things they can do, like I've already gone into one of the things they can do basically, which is going more into making more policies that are more streamlined and more focused on particular areas which we are seeing problems in. Secondly, I would say we also need a system of we need a more robust system in terms of complaints. Yes, we have them now, but how quickly are they, right? So if I have if I go to Jumia, for instance, I order something, maybe I order a chair, and then it comes, the chair I order for like 10,000 naira is what is the miniature chair, is the toy chair. How quickly can I get that issue resolved, right? I wouldn't want to take something like that to court. So that's part of the reasons why, that's part of the things we have to take into account when we're trying to protect consumers. Even the things that are easy, things that are simple, we need to give them an avenue to air their issues. So we need to have that specific consumer, how will I put it? We need to have a process where consumers can easily lay their issues, and the issues are easily resolved quickly when they have issues like that. Secondly, of course, sensitization as well, which a lot of the regulatory bodies do. I guess just have to keep doing more of it. And not just general as well. It needs to be fixed in terms of where a consumer protection can be breached, because the whole consumer protection space is a bit special in terms of you're trying to protect somebody that doesn't want to protect themselves, really, because they see these things and sometimes they don't want to do it, right? So there has to be that proactiveness on the part of the regulators as well to protect consumers in that aspect. Yeah, I think that's it from me. Thanks.
Before I come to you, Ifedayo, if anyone has any questions, you can drop it in the chat box so we can see them and address them at the end of the panel session. Over to you, Ifedayo. I can see your hand raised.
Okay, thank you very much, Victoria. Hi, everyone. Nice to meet everyone. Okay. Timi Ebi, sorry, terrible with names, said a lot and covered a lot of basics, but I would definitely say that the legal framework in Nigeria is lacking. It's ridiculously lacking. Like I was working on a paper recently, and I was trying to look into the extent of protection offered to consumers in Nigeria vis-a-vis developed countries. So I'm looking at the United Kingdom, looking at the European Union, which is believed to be the most developed consumer protection jurisdiction in the world. And I think the issue with Nigeria, protecting consumers in Nigeria, starts from the extent provision of the law. So I'm looking at common law. Nigeria is built on the extant principle of common law. And the issue with that is that under common law, buying and selling online is a contract. So everything goes under contract law. Fine, we like to talk about consumer protection being, or e-commerce law, or data protection being a separate area of law, but it's generally a subsection of contract law in the real sense of it. And the extant principle of contract law says that party autonomy, I can decide what to put in a contract. You can decide what to put in your contract. Then there's caveat emptor, where buyers are responsible for protection of themselves. Then we go all the way around, we go to freedom of contract and all of that. And the issue with that is that what that does is create an imbalance of power in the market space. So we have sellers more powerful than consumers, because sellers dictate the term. If you're buying online, you don't negotiate. You don't have the opportunity to negotiate. You can't even contact Jumia until you've made purchase, because when you contact, the customer service agent will ask for order number. So you can't confirm to clarify certain information. Therefore, buying and selling online heavily relies on the information presented to you. And then the extant principle of contract law comes in, that there's no mandatory obligation to disclose to you. Sellers don't have a mandatory obligation to disclose to you. They can disclose what they want, and caveat emptor comes in where you have to protect yourself. And now that is the problem. Section 114 of the FCCPA, which I can't remember her name, but the representative of the FCCPC, today Rukera, came in and said a lot about Murayo. Sorry, Murayo. I'm terrible with names. I think I clarified that earlier. And Murayo said a lot about Section 114, and why Section 114 of the FCCPA is an improved development. Consumers in Nigeria are unable to make informed decisions. I think that's number one thing. Information are displayed in plain and understandable language, fine. But are the relevant information being provided to consumers? That's the first thing we should start. If you look at the European Union mandates that you must provide 22 information, the identity, characteristic of the good, the mode of payment, how payment is being made, amongst others. South Africa does the same thing. The United Kingdom does the same thing. But the FCCPA, which is a new law introduced in 2018, did not. Still respected the extant principle of contract law in the country, which says that it is your duty to seek information that are profitable to you. And that is the gap. And that is a very huge gap that needs to be addressed, because information is the foundation to consumer protection, especially in the digital market. If you don't have the accurate information, you can't make informed purchase decisions about the product. You can't make informed decisions about your rights, because you don't even know what those rights are. And I believe that, I wouldn't say I believe, okay, and as evidenced in several jurisdictions and as functional in several jurisdictions, there should be a responsibility on companies. I'm looking at Jumia, I'm looking at Konga, if they're still viable in the country, and I'm looking at all consumer protection or e-commerce platform. There should be a responsibility on you to inform consumers of their rights. It's not everyone understands the law. Not everyone knows where to find the law. Not everyone knows their right. And because of that, if you go to Amazon terms and conditions, you see your right as a consumer. There's a subsection in there. There should be a provision to inform consumers, because information is the foundation of consumer protection. And while the FCCPA in 114 did a lot of work by trying to simplify the provision of information for consumers, the provision is not as effective as it is meant to be, because there is no mandatory obligation to disclose specific information that would have assisted in making decision of whether to purchase or not, or how to enforce right. So in the real sense of it, Section 114 is as useless a provision, with all due respect, as it is, because the essence of it is that if you ask that information be provided in plain and understandable language, and you don't provide the information to be provided, it's an effort in futility. Now let's go all the way back to what Timi Ebi said. Timi Ebi talked about access to justice, and with specific point, I think I wrote it down somewhere. He said, there is a need to create a dispute resolution system where consumers can easily resolve their dispute. Fine, I agree with that 100%. But the big question is, dispute resolution doesn't work in Nigeria. If you go to court, I practiced, with all due respect, I practiced in Nigeria for 6 years. And the big issue I have with it is the cost of jurisdiction, cost of litigation. So I go to court, I pursue a case, and Justice Olayemi would offer me 1,500 as the cost of litigation. And the question is, consumer contracts are low. I'm buying a mug for 5,000 naira, and I have to go to court and spend so much to defend my rights. Am I actually being protected? Because Justice Olayemi would not give me more than 1,500 as the cost of litigation. So what is the incentive to go to court? And now that trickles back to the development of consumer protection law. Sorry, I know you need me to go off.
Yeah.
I would go off. I am just saying that there's a need, since we have a representative of FCCPA, there's a need for a self-enforcement mechanism, like the right of cancellation. Thank you.
Thank you so much. I think one profound thing you said is the fact that information is the foundation of consumer protection. You can't protect what you don't even know anything about. And from what the speakers have said over and over again, there is this depth and lacuna in the education and information space when it comes to consumers and the digital economy. So to my next question, I'm going to paint a picture. So I ordered something on AliExpress from a Chinese vendor, although they have their own internal disputes or consumer protection mechanism on the platform. But something goes wrong somewhere. Maybe I ordered a 50-inch, or I thought I was ordering a 50-inch plasma screen, and then I order and I pay. I'm like, oh, this is the steal. And I get like a really tiny box, maybe 10 inches or 15 inches. And I'm in Nigeria. The vendor is in maybe Indonesia or Singapore. So this, because of the nature of the digital economy, because of the nature of the global market, which we are moving to, because the internet doesn't have borders like that unless you're in China. So how do we address consumer protection issues that are cross-border? So one of the nuances of the digital age is that the world has gotten smaller very quickly. And in a bid to create a global market, territorial lines have gotten blurred. So you can be in Nigeria and you are dealing with a vendor all the way in South Korea or in the US. How do we ensure that what is cross-border consumer protection? Is it a thing? Is it possible? And how do we make it work? How does it work in practice? So I think I will take Fedayo again and then Francis after that.
Okay, thank you, Victoria. Okay, I think I would just, I'll continue from where I stopped, but in answering your question, I would continue with self-enforcement. There's a lot of issue with cross-border enforcement of consumer rights. It's a big problem, but it's a big problem which developed countries are starting to find solution to. And some of this solution goes to self-protection mechanism. There's a need to have structural frameworks in place where consumers can self-protect under the umbrella of the law. One of these is the right to cancellation. I buy something, I don't like it. It doesn't work for me. It works for me, even if it works, but I discover that the money in my account is not enough or something. There should be those mechanisms like the right of cancellation that allows you exit from a contract within a particular period of time. Apart from that, those things they're bits and pieces of consumer protection framework that try to alleviate the struggle in cross-border transactions. Moving away from that, there are international dispute resolution mechanism that uses a lot of, it's like an online dispute resolution, but a subsection of most countries. AliExpress will not be a perfect example because the same issue Africa is having with cross-border consumer rights, protection of consumer rights, is the same thing, is close to what Asia is going through. But I would still bring it back to the European Union or Europe. The European Union, through the European Commission, has online dispute resolution as one of its core ways to resolve cross-border transaction. You buy something from Netherlands and you feel like my right has been infringed or something. You can go online, sign up to the European Commission, use their online dispute resolution. I have used it a couple of times just to try, just to check, because I need to do a bit of research about it. And it works, it's functional, it's cost effective. You get your cost of litigation back. Whatever you pay to use the mechanism, if the case is decided in your favor, the seller pays back. And sometimes it's free and close to stipend. It is hard to enforce cross-border consumer rights, but I think the best move is to put in self-protective mechanism where consumers do not even have to approach dispute resolution at all, where consumers can individually, because of the legal structure in place, protect themselves and restore themselves back to where they were before the transaction. And then in extreme cases, go to online dispute resolution. Thank you.
Before I come to you, Francis, I have a question, a follow-up question. You kept talking about this right to cancellation. How would it work if the service has already been provided and money has changed and delivery has been made?
The right of cancellation aims to put you back to where you were before the purchase was made. So if delivery has been made, I have, like in England, you have 14 days. I have 14 days to return whatever I've purchased within 14 days. I have 14 days to return it and you refund me everything. Well, with certain twists and turns, especially if you're returning because you don't like it, then they won't return delivery cost. There are situations in which they would return delivery cost, but you get your money back. You can cancel a contract within a given period. And that is because when you're buying online, even if other services, if I sign up to Vodafone now and within 14 days, I feel like I don't like it, I have 14 days to cancel and get my money back. I understand that it's not favorable to business, but there's already an imbalance of power in the market. These things are structures to re-level the playing ground and put consumers at, if not the same level, at a given level of advantage.
Thank you. I just needed you to clarify that, because cancel might seem, oh, prior to delivery or while you are still in shipping phase or while the contract is still in negotiation phase. So I needed you to clarify that. Once again, if you have any questions, please drop it in the chat box. Over to you, Francis. I'm working with an assumption that you are not within Nigeria, because I know that this conversation has been very lopsided when it comes to Nigerian consumer protection and Nigerian consumer protection mechanism. So I want you to give some context to the conversation from what happens within your jurisdiction, especially when it comes to cross-border consumer protection.
Thank you very much. Yeah, you're right. I'm not within Nigeria. I'm in Kenya. And there's a saying that is online that Africa is a big village. And I think it's true. The same issues that you're having at Jumia, same issues you're having at AliExpress of receiving goods that you thought are this size and then they receive a smaller miniature size. But the same issues we also face over here. However, just to add on what my colleague has just said, I think the biggest issue, the biggest challenge that we're having in Africa is that we're not united. And because we're not united, when you're trading with entities outside the continent, or even within the continent, you do not have an authority that can be used to ensure that there's order within the trade system that is being used. For example, now you're importing something from China, and then it's not what you thought you are ordering. Where do you report it to? Is there an authority? No. In Europe, they have already, under the EU, they have these systems in place. You can complain. Let's say if it's we're buying from Germany and in France, there's an authority in which you can report that issue to, and there will be fines to the entity, and action that will be taken. In Africa, at the moment, you do not have such systems. And I feel like we will still continue complaining until we unite as a continent, have instruments in place, legal instruments in place that will help us in ensuring this consumer protection. And that will actually be the solution to all these problems. Otherwise, right now, if I'm to order fabrics from Nigeria, you can easily scam me. How will I report you? To who? I think the worst thing that I can do is just cancel you online, but I'll lose my money. But if we have systems in place where I know that if somebody attempts to scam me, I can go and report them. I can have their accounts frozen and such stuff, or they'll be fined. Then it will also lead to more people trusting online trade. It will lead to growth of this trade. Because now also with COVID, physical activities or physical trading kind of stagnated, but online trading grew, especially now in Kenya. And I'm looking at a situation where, in a cross-border situation where you can order something from another country and bring it into your country online. If you have good cyber consumer protection systems in place under let's say a continental instrument that countries have ratified and have signed, and there's also there's a body that is active and will actually take action, then these things will be seamless. So I think the issue is that we are not united. We do not have systems in place to ensure that the consumer protection laws in place, and because of that, the challenge will still be there.
Thank you very much, Francis. Baby, I want to hear your input on this, and then you can take it alongside the next question, which is, what challenges do the government face when it comes to consumer protection, and how can they deal with it? Because I'm sure we have regulators here, and they are open to having suggestions from our panel of experts. So I want to hear your contribution on the subject of cross-border consumer protection, and then a little bit on recommendations for the regulator on consumer protection issues.
Hello. Okay, so about cross-border issues. So, Ifedaya and Francis have really spoken extensively on this, but what I would say about it is that cross-border transactions, actually, they bring up a whole, lot of problems and stuff like that. You have like some businesses that will use like virtual borders, to evade, following regulations by setting up in one country and then selling to consumers in another country. And when we're talking about consumer protection in that context, I know that a lot of developed countries in this sense, they've adopted their laws to increase their ability to, cooperate with their foreign counterparts and everything. And, such laws like that, they focus on, information sharing, investigative assistance, and cross-border consumer redress. And for instance, now we have the FTC in the US. I know from research that they, respond to information sharing requests with various foreign counterparts. And we also have like, I think Canada's anti-spam legislation, which enables their consumer protection authority to share information with their foreign counterparts as well. So apart from international cooperation in that sense, we could also have like agreements and MOUs between countries as well, to encourage, consumer protection in the cross-border context. In Africa, there are legal limitations. We can't say there's a lot of cooperation between, African consumer protection authorities. And I think the other two speakers have spoken on that. If I were to say, speak on recommendations for regulators now, I would say it's just to basically amend the legal frameworks that we have, work on enforcement of the provisions in our legal frameworks, educate consumers, and yeah, that's what I would have to say on that. Thank you.
Thank you very much, Bemi. I know during this conversation, we've spoken a lot about what the government should do, what the government can do, but then we've not said anything or said enough about what the platform providers, technology providers should do should they be concerned about consumer protection at all? And how do they create a balance between profitability or capitalism in quotes and consumer protection? I can see your hands up, Fedayo. Please go ahead.
Thank you very much. I think businesses have a conflict, and the big one is, how do we merge our bottom line with protecting consumers? Businesses are expressly and always focused on profit making. And even though we can all say, oh, they have a moral responsibility, they have this and that. Morality is subjective. Responsibility, they feel like they have a responsibility not to go out of business. Why you feel like they have a responsibility? I was watching Mark Zuckerberg go before the European Commission a few years ago, and you can see that he feels like he's being persecuted. While to an average consumer, I feel like those are the things he should do to protect my interest while using his product. I think all we can say is corporate organizations should do this. But I don't think it will work, with all due respect, unless they are mandated to. A lot of people say, oh, don't make goods in Vietnam, don't use child labor, don't do this. But a lot of fast fashion still do. Unless you put in legal frameworks that mandate them to, they wouldn't do it. We can put responsibility on them. And I think it's going to be a wasted effort to preach to the person that is not ready to listen, or that it doesn't even make sense to. Because from their point of view, you asking me to be able to cancel a contract after I have enjoyed the product for 10 days is unfair to my bottom line. And that is
Can I jump in here?
Yes, please.
Is it possible to incentivize this, like carrot and stick approach, not just penalties and legal punitive measures? Is that something that can work in this space?
Then if we're talking about incentivizing, then we're bringing in regulatory cost. And the issue with regulatory cost is that it is always passed back to consumers. If you tell Jumia, give Ifedayo a right of cancellation, because it is your responsibility to make sure that if he's not satisfied with your product, he can return it. What Jumia would do is they would add 2 Naira or 3 Naira, just as an example, to all of their products. And all the consumers in the market will pay for the cancellation right that either only Victoria or Ifedayo or Gbemi would exercise. Everybody will pay for that cost, because businesses will always make a balance. So incentivizing comes to regulatory cost. And that is where I push back a little bit about incentivizing businesses. I think businesses should be made, and there's a representative from FCCPA here. And the question that we should be asking is, why is the FCCPA, that is FCCPC, sorry, the body responsible for protecting consumers in the country, neglecting electronic consumers? Because I think that goes back to it. We see Tunde Rukera go to Creamy, whatever they make, donut or something, to enforce, go to PHCN, but we don't see him talking about Jumia. We've not seen him talking about the unfair practices perpetrated by a lot of these e-commerce platforms. So going back to the question, I genuinely think saying that there's a responsibility, a moral responsibility, or a market responsibility on corporation is a waste of time. I think it should be, there is a mandatory, I know a lot of people are capitalists on this panel, and you preach for minimal intervention into the market. But my question still remains. Businesses would not do it unless you make them do it. And making them do it goes to FCCPC, a body that is equipped to issue regulation, delegated legislation. But I've not issued any regulation in 3 years to protect e-consumers, which is the future of commerce. A body that throughout the entire FCCPA did not mention electronic consumers once, or distant contracting once. And I still feel we don't need to go to corporation. They won't do it. Facebook, Google just got, I think it's 3.2 billion fine. They will not do it because the bottom line is important to them. There's a need on government to come in and protect and intervene into the market to the extent not appreciated by a lot of capitalists, but it is still important that you intervene into the market to mandate cooperation rather than obligating them or shaming them into doing it. Thank you.
I think you have a very interesting perspective, and I'm sure our regulators that are on here are listening and taking hints and suggestions from our panel. Before we go to our final question, I would like to hear Tibi's perspective on this subject of providers, platform providers, technology providers, and consumer protection. Okay, I want you to take it from the angle of, do they derive any benefits from consumer, for being known for having good consumer practices? Maybe it's a way that can encourage providers to actually do better.
Yes, well, to be honest, I actually align a lot with what Ifeda said to a certain extent. We're in a capitalist society, and what came to mind immediately was I know there was an issue of car recall once, where some auto companies made a decision that the fine they were going to pay or the lawsuit was going to be less than recalling the vehicles, and they decided, okay, it's a business decision. And that kind of came to mind in terms of data protection as well. In that regard, in terms of, okay, there's a fine laws to this, but still, yes, I think there's an advantage to having that good reputation. I mean, look at Facebook, for instance, and they have terrible history of doing a lot of tweaks with our personal data. It does, but the question comes to, will customers still be willing to forgo? Because the whole idea of data came in because of this whole idea of freemium, right? The paying of your getting free services in exchange for your data. Will customers be willing to forgo that, even if they know? I mean, Facebook has had so much bad records, but they still have the highest amount of users. I think they have over 2 billion users still, right? Active users. Right. So there's that part of using it, yes, fair enough. Even if they do it, they have the good rep and the rest, but consumers, like I said, this is a field where you're trying to force people that don't want to protect themselves properly because they need to, right? So will consumers be willing to forgo all the services that they have just because of reputation? Certain extent, yes, but I don't think in the whole schema of it, everybody would align. I mean, some people would out of principle, but I don't think everybody will align in that perspective. Thanks.
So we're saying the way to get tech providers and platform providers to actually care about consumer protection is to make it the law, have policies with punitive measures attached, so they know that we are going to pay for our bad practices and not just encouraging them or talking to them over and over again, because in the capitalist economy, the bottom line is what really matters. To my final question, in the digital economy, we know that technology is constantly evolving. So as I mentioned at the beginning, when consumer protection ranged from, okay, you have a right to inspect and all that. And now you really cannot inspect, you just see something on the internet and you buy. It has evolved now to e-commerce and is constantly evolving. So the consumer protection issues we face today may not be the consumer protection issues we deal with tomorrow. So I just want us to take a peek into the future. What is the future of consumer protection? And what are the emerging issues that we need to begin to pay attention to? Maybe they are not in our faces right now, but it's an emerging issue that we need to begin to look at with regards to consumer protection. I'm going to give all my speakers 2 minutes each. 2 minutes each, because I think we're out of time. I don't have any questions here, so we'll be rounding up this session with those questions. So I'll take Francis first. Francis, are you still here? Okay, who wants to go first? I really cannot see the question. I'm told we have questions in the panel session. I really cannot see the question, so I'm going to take this part and try to find the question while our panelists are rounding up. What is the future of consumer protection, digital economy? Francis, are you still with me? Baby, do you want to go? I don't think Francis is here. Can anyone hear me?
Yes, we can. I think so.
Okay. Okay, so I'll take the question now. I'll take the question, I've seen the question. So here it is. And can make this full screen. So websites use manipulative, deceitful tricks, UI designs, dark patterns to trick consumers into making unintended and possibly harmful choices. Examples include deceptively labeled buttons, choices that are, it's difficult to scroll on this platform, choices so sorry, I cannot scroll on this platform. So examples include deceptively labeled buttons, choices that are hard to undo, e.g. subscriptions. Are there examples of good practice or frameworks to regulate such deceptive practices? So I think I'll let Francis take this question. Okay, it's not here. So if I please, can you answer this question?
Okay.
If you can see it.
Thank you. Yes, I can see the question. I still go back to self-protection because thank you, Kaushal. I'm so sorry if I'm butchering your name, but I think the important thing is to allow self-protection mechanisms, easy to remove. Sorry, I think I'm struggling to see the question. Okay, so it is important to have in place self-protection mechanisms. I'm always going to go back to that because, for example, allowing people to exit contract, mandating information, saying that if you are asking me, before you ask me to subscribe, you have to label your product this way, putting in refund, insurance, card refund. So let me give you an example. Chargeback frameworks are very important. It is very hard to get chargeback back from Nigerian banks. However, it is easier in the European Union, in the US. I was talking to a financial expert recently, Temitayo Iwoli, and she works in a bank and she works with chargebacks and all of that. And she said something to me. She said, all you have to do is allege. I buy something and I am saying as a consumer that I never received my goods. I never meant to enter this subscription. I think using self-protective mechanism or using the financial sector, because it all boils down to the amount I paid for it, to undo these deceptive practices is the best way to go by it. The best thing to do is put in good chargeback laws in which an escrow arrangement is made. So if a deceptive consumer says, okay, I do not mean to take the subscription, you investigate it, something like PayPal chargeback, PayPal dispute, sorry. Things like that, those are structural ways in which you can prevent deceptive labeled choices. Because in all honesty, because of the virtual nature, because of the virtual blanket in the digital market, you cannot eradicate deceptive practices in the digital market. You can only put in frameworks that reduce it. And the best way to do is put in good chargeback practices, introduce the right of cancellation that allows me to leave within a period, introduce information rules in which you cannot use manipulative ways. If you are telling me, click here to subscribe, I am clicking here to subscribe. I need before, like the European Union Article 6 says expressly, one of the subsection there says that for you to be able to have a contract binding in a digital contract, which e-commerce is one of them, the label, the pay now button must be conspicuous and big enough where I would know that this is what I am paying. This is the amount I am paying. It is at this point I subscribe. I will know expressly by clicking this button, I am subscribing. And those are ways in which you can control it. But in reality, you can't really take away deceptive practices. Because if I say today that if Victoria finds out the way to stop me, if Victoria finds out the way to stop me from deceiving her to make payments, if I am a deceptive perpetrator, all I have to do is just do a bit of research to get back to her and be able to convince her the next time. So I think in the real sense, you just have to keep working and keep introducing mechanisms. And that is where the delegated power of the SCCPC, which they have not used, comes into place. Thank you. Victoria, you're muted.
My apologies. I thought my mic was on. There is a question for Francis here, but Francis is no longer on the call. I think he dropped off at the point, at least I can't see him. But yes, is there a way the AfCFTA could impact consumer protection in Africa? Maybe. And then your final words.
Hi, Victoria. I think I'd actually like to hear Ifedayo's perspective on this question, if that's all right.
Ifedayo, over to you.
Sorry, I missed your question. I had a bit of technical glitch. Sorry.
Is there a way the AfCFTA could impact consumer protection in Africa?
Well, it has to go with reciprocal arrangements. The ICO here that talks about information works a lot with the European Commission. Even it's something like the tax arrangement. I don't know if there's a tax expert here in which you negotiate reciprocal arrangement. Okay, recognition of judgments. I know a lot of people here are lawyers. The reciprocal approach in which you tell South Africa, we can work together and set up a collective platform. If anyone buys something from you and there's a problem, we will help you chase the trader in Nigeria and the other way. The FCCPA can do a lot of that. They can, the FCCPC, sorry, I keep mixing it up with the act, can do a lot of that. And another one is building relationships. I think in Africa, I am most impressed with, maybe because of the jurisdiction I've actually explored a lot, South Africa and Ghana's way of handling consumer dispute. It's more of, we protect the reputation of our traders by ensuring that they comply. So if there's a problem, and you contact the South African Consumer Protection Council, and you say to them, this is what has happened within your jurisdiction, this. It's like a reputation thing in which we're trying to protect the reputation of our economy vis-a-vis consumer protection.
I'm sorry, I have to butt in, but I'll need you to like round up because we're out of time.
Thank you. So I think it all goes to reciprocal arrangements. I think we need to pin it down to the FCCPC putting in more structure to ensure that on the international stage, Nigerian consumers are protected.
Thank you very much. We've learned a lot on this panel, but now I'll have to take our last words. Maybe particularly on the future of consumer protection. What are your last words? I think now it's 1 minute each because we are totally out of time. We are eating into another session for this event.
I'm sorry, I didn't get you.
Your last words, recommendations, or your take on the future of consumer protection. Just 1 minute, please. Thank you.
Yeah, so I think as more businesses go more into the digital economy, I think the problems we have now are going to become more exacerbated. They're going to become more pronounced, really, and are going to affect every facet of our lives. I mean,
I'll need you to project a little more. Thank you.
Okay. Can you hear me now?
Yes, I can. Thank you.
Okay. Yes, I said as in the future, I guess the problems we're having now, I see them becoming more pronounced and more exacerbated because technology and the digital economy will have gone more into other parts of our industry, other part of the economy. And we'll be facing these problems in different areas. I mean, people are trying to build up tech solutions to different parts of the economies now to try and solve problems. So this particular problem of trying to protect consumers properly when they are interacting through a digital platform or through a digital economy is something that's going to become more prominent and something that we need the regulators to take more account into and to provide solutions, specific and also very tailored solutions, not general overarching protections that we have normally.
Specific solutions. Over to you, baby.
Okay, so as a last remark, I'll just say that consumer protection, I think the future, it's just going to keep evolving. We can't really say what's going to happen in the future. With more technological advancements, new issues are going to crop up day by day. So I think the thing for us is just, to brace ourselves and to make sure that our frameworks, our laws are open and amenable enough to accommodate whatever, comes up in the future. So yeah, thank you.
Over to you, Fedaya. Final words. Last words.
So thank you. I think I'll just keep it brief, 30 seconds. I know you're laughing, Victoria. I promise it's going to be 30 seconds. I think it goes to sensitization of the consumers. Consumers should be equipped enough to be able to protect themselves. I think that's the most important thing, because with the market evolving, consumers should be able to know that, okay, this has changed and this is the way I will protect myself. 24 seconds.
Thank you very much.
You're muted, Victoria.
I thought I turned on my mic. I didn't know I turned it off. I said I think Fedaya touched on a very important point, which is sensitization and education of the consumers and even platform providers, because some of this, we can't just assume that the ignorance is only on one end of the divide and not across board. So even for people who work with the regulators, for consumers, for platform providers, it's important to keep this conversation going, because the law cannot just stay in one place. The regulators also have to keep up with the law. The consumers have to keep up with information, and information, they say, is power. Information is power, and it's a very general saying that we have. So I think some of the things I will take away from this panel discussion is that information is power. Consumers should be given more power, because within the current dynamics of data economy, there is a clear imbalance of power. But then there is a need to balance consumer protection and profitability on the end of platform providers, because they are in it for the business and in it for the money. So I think we need to have a discussion between the stakeholders, and these discussions need to keep going, where we balance the interest of the regulators, the interest of the providers, and the interest of the consumers. I think we've come to the end of the panel session. I'm saying a big thank you to all my panelists. Thank you for your input. I've learned a lot from this session. And now I'm going to hand over to Alero. I'm so sorry if I add into the time, or if I went over my allotted time, but it was a very interesting conversation. Over to you, Alero.
Thank you very much, Victoria. Thank you to all our panelists. It was a very interesting panel discussion and a very interesting conversation. I've learned a lot about the rights and the duties of both the consumers and the providers of these platforms, the sellers. One thing I've learned is one of the prevailing thoughts is the need for education on both the consumers and the sellers. So we would be moving next to the next up. We'll be having the announcement of the winners of the Adavize Alao essay competition on privacy and data protection, and this announcement will be made by a family member of Mr. Adavize Alao in the person of Omeiza Alao. Omeiza, are you there?
I think Omega is raising his hands. Just give us a second to figure out what the issue is. Thank you.
Okay.
Okay, he's here now. He's here now.
Good afternoon, everyone.
Good afternoon.
Good afternoon.
Okay, so it's a pleasure being a part of the symposium, and I've benefited a lot from the panelists that have spoken earlier. So I have one task, and that is to announce the winners of the essay competition, and I'll do just that. For the students category, the second runner-up is Mr. Forgive me if I mispronounce any names. The second runner-up is Mr. Dureke Clinton Charles. The first runner-up is Mr. Sino Victor Akimusiri. And the winner for the student category is Miss Sibi Dorcas. Sadly, I can't really pronounce the last name, but the winner for the student category is Miss Sibi Dorcas. For the young lawyers category, the second runner-up is, sorry, one moment. The second runner-up is Mr. Olawi Tolani Mustafa. The first runner-up is Mr. Chidera Emmanuel Chikere. And the winner for the young lawyers category of the third Adavize Alao essay competition is Mr. Gabriel Temitope Omoni. Thanks to everybody that sent in their entries, and congratulations to the winners.
Thank you very much, Mr. Omize. Congratulations to all the winners. Thank you for sending in your entries. And thank you all for joining in and staying through this session. It has been an interesting and amazing session. And to close the session and to round up this symposium, I will be inviting the co-founder of Lawyered, Mr. Toby Adibowale, to give the closing remarks.
Hi, good afternoon, everyone. Pardon me, I'm unable to share my video at the moment. But thanks to everyone for participating, for joining in. I have to thank everyone who has been a part of this process, particularly Banke Lori Oyini and Ridwan Oloyede for leading the charge in organizing and putting this year's edition of both the essay competition and the symposium together. Thank you, Alao, for being our host today. And Victoria did a great job moderating the panel session. I also listened to the very insightful keynote address from Morayo, as well as Dr. Simi Akitoye's intervention, all very insightful, incisive, and concise, yet concise. To everyone who participated in the essay competition, I say kudos, well done. We're all winners. The fact that some people may have emerged ahead of others does not mean that the work submitted by the others fell short of quality. No, it's just that because it's a competition, it's a game, you just have to have some winners. So I really thank you for participating in the essay competition and urge you to keep doing research around this area and enhancing capacity in this regard. Also, very importantly, I must thank our sponsors from Duale, Ovia, and an executive law firm where Adavize Alao used to work, to TechHive Advisory, Privacy Legal Services, Ikigai Innovation, Lego Ninja, Taiwo Akini. This is Dr. Simi herself, and every other person who was supported one way or the other. We're really, really grateful. Without you, we'll not be able to continue to do this. And if you note, we've been able to expand the number of beneficiaries in terms of prizes from just 2 in the first year to 4 last year. And now this year, we're giving prizes to first and 2 runners up in each category. So that's making 6. And with time, we're going to probably be able to do much more. And I'm very grateful to Ridwan and TechHive Advisory team, for instance, for paying for these expensive trainings with the IAPPA to get certification, over $1,000 for each person. Yet they've gladly borne that cost. I must say a very big thank you to them. To everyone who stayed on till this moment, from the beginning of the symposium till now, thank you for your time. Thank you for your attention. Thank you for joining us to celebrate and preserve the memory of Adavize Alao. We all miss him, and the little we can do is to continue to build on what he started in the area of data protection and privacy. And it gives us great joy that, for instance, we're able to continually attract top-level management in terms of regulatory agencies connected with data protection and privacy. In the first year, we had NIDA. Last year, we had someone else. And then this year, we've been able to bring in the FCCPC. So it's really, really delightful. So, and I must say, we wouldn't have been able to do that if we not had consistent following and participation by different people, young lawyers, law students, and non-lawyers. So I'm very grateful to everyone. I think I will stop here so I do not hold the mic for too long, and wish everyone a pleasant afternoon. And then hopefully we'll be able to see at a physical symposiums for next year if COVID has completely been taken care of, so to speak. I look forward to seeing everyone again at some point in time. Until then, keep well, keep safe, observe the protocols for safety out there. And if you feel anything, please proceed to do a test just to ensure that you're getting the right attention you need. The recording of this event will be made available. You can check on YouTube, on our page, on the lawyer page on YouTube. And then this is currently being streamed live on Facebook. So the recording will also be available there as well. So if you missed out any part or portion of the symposium, you can catch up later on. And for those who are unable to attend because of a meeting or work or anything, they can always come back to revisit the content. Thank you, everyone. God bless. Okay, I guess I may have to then announce that we'll be closing the page. Thank you to everyone. I missed out on Garnet earlier. Thank you, Garnet, for sponsoring as well. So we'll be ending the session now. Have a good afternoon, everyone.